Okay, and then can we call the Gavino and Cook matter, which is on for the guardian ad litem report? There we have Ms. Baldwin representing Mr. Gavino, Mr. Zandy representing Ms. Cook. And from my review of the file, I didn't see a GAL report. Is that accurate?
That's accurate, but this isn't really a GAL, a traditional GAL report review. This was really on for an interim review. I asked my staff to reach out to Ms. Turnbull because I don't see her on. So I'd ask we just bump us a little bit and come back.
Later in the docket, you're asking?
Yes, please.
Okay, Mr. Zandy, okay with that?
I was under the impression that it was a GAL review as well. And no, I have not received anything from Ms. Turnbull. I know that investigation is ongoing, so I'm really not sure what we can do today. There's been nothing really filed or submitted by either of the parties, and we're just kind of waiting for that information from the GAL, which I think was the intent of today's hearing. So I would just suggest we set it out until we get said report, maybe another 2 weeks. And then by that time, hopefully Ms. Turnbull has had sufficient time to publish something.
I'd like to talk to her just so that we know. So I'd hope to get her on the line and then see where we're at.
Okay. Have either of you had any direct contact to know whether she's planning on attending the docket? I mean, she should be, but
I have not.
No,
okay.
I'm having my staff reach out to her right now to see if we can get her on the line.
Okay. Yeah, I'm fine if we come back to it with her on the line. My review of the case file is that the only thing that's been filed since we were last here was just some updated protection orders that were previously entered in different cases. So once she gets back, we'll come back and Mr. Anagnostou representing Mr. Abul. It looks like both are present on the line today, and I've been handed a proposed order requiring counseling and continuing the mandatory settlement conference that was presented by Mr. Anagnostou. So I'll hear from you, Mr. Anagnostou, and then Mr. Zandy, please.
Yes, Your Honor. This is my client's motion under RCW 2609030, subsection C. It indicates that that at the request of either party or on its own motion, the courts can transfer the cause to family court, refer them out to another counseling service of their choice, and request a report back within 60 days. The one case that discusses this is Little v. Little. It's a 1981 case when it's talking about the new statutes. And it just verifies there's an additional 60-day provided where counseling is ordered under this provision, which I think is a carryover from old law prior to the current statutes. So they were incorporating what was part of our history here in Washington into the new statute. And quite frankly, I haven't run across this. I talked with counsel. This is kind of a new issue, but as indicated in my client's motion and declaration, he has a long, loving, this is a love story between my client and his wife from middle school to currently they're, in their 80s. So we would like to explore counseling, order counseling. That's the request. That's what's provided under statute. Set this out for a report back from counseling in 60 days, pursuant to the statute, and see if we're going to go forward with this dissolution or a legal separation, or if the parties are going to, somehow reconcile, which is what my client wants more than anything.
All right, thank you. Mr. Zandy.
And thank you, Your Honor's court's aware I do represent the petitioner, Marlene Abel, in this. And I think from a factual standpoint, my client is somewhat concerned about this relationship being treated as dating back to junior high. There's a lot of back and forth on that. I think it's largely irrelevant. What we do know is that these parties have been separated for an extended period of time. This is about an 11-year marriage or so. Both parties had properties coming into the relationship and such, and unfortunately, it's now done. And this matter was filed back in October of 2021. Here we are now, nearly 17 or 18 months later. My client has been patient throughout this process. We've exchanged discovery. We have been in on temporary orders. We have had a settlement conference date that was initially scheduled for back in the fall, which was by council's request, Mr. Abel's request, continued. We now are on the verge and the eve of a second mediation, which is Thursday of this week. My client wants some resolution. I have some concern that we are a year and a half into this process and on the eve of settlement conference, which frankly is a case that should resolve. But on the eve of settlement conference, we have what my client is concerned about is another kind of a delay tactic in that. I will say that Mr. Abel was pro se at the onset of this case. Him and I had a couple of very good, productive conversations. He was very respectful and civil in his approach with me. But in every approach, he's made it well known that he wants to reconcile the marriage. And I think there needs to frankly be more people like that. I think that is certainly admirable and positive, but this is not a case where reconciliation from my client's perspective is appropriate. My client has had issues in the past. She did have some matters pertaining to anxiety and such prior to the date of separation. We've had her reviewed at Kaiser, and since that time, since the parties have separated, her life has been more stress-free. I don't know what the affiliation or the association is between those two things, but I know that she's moved in a positive direction over the past year and a half. We would like to continue on that. She now needs one thing in her life, and that is just to resolve this matter. At this point, she doesn't believe that counseling would be appropriate. She doesn't think that it would be productive. And again, given the fact that she's been kind of battling through this, again, in her 80s for the better part of a year and a half, just trying to get divorced, the timing is somewhat questionable on this. If this would have been presented at the onset of this case, I think there would have been more validity to that, but we would certainly argue that there's a reasonableness standard to this. And waiting again after discovery has been exchanged, after temporary orders have been entered for a period of time, after a cancellation of one settlement conference and on the eve of another to make this request, this is going to put us out, another 6 months. And my client does not want to wait 6 months to do that. So we're asking the court to deny the motion to proceed with the case as currently pending, to allow these parties to go to the settlement conference. This is now the second request made by Mr. Abel to strike that date. And again, my client's best interest is serve getting some kind of resolution to this matter and moving on with life, because I think we can all agree that life's too short to be going through a contested, lengthy dissolution of marriage action, especially at this juncture of both parties' respective lives. We are asking you to deny that motion and allow the parties to go forward with the MSC, which is scheduled for Thursday.
Thank you. Mr. Anagnostou, one question. The request is made under, as you mentioned, under 2609030 C2 for counseling service. And if memory serves correctly, the pleadings indicated that there was some indication possibly of capacity competency, and that was the basis, not necessarily a counseling or reconciliation. Am I off on that?
No, my client, has been concerned that Mrs. Abel is being manipulated or taken advantage of. And that's why in his motion, he's requesting to have a counseling session without her family present so that he can talk with her. And if a divorce is what she wants in a counseling session, then he's going to have to be resigned to that. He was representing himself the best he could. He indicated in his handwritten response that potentially this should be a legal separation and not a divorce. That's the best he could do. He's not a lawyer, and so that's the basis for the motion. Is that he has indicated that he was concerned about her being able to make decisions, but that aside, that's not what we're pursuing. He does not want this divorce, and he wants to communicate that to her. And if she wants a divorce, and it's not a 6 month, counsel kept mentioning 6 months. It's not. It's 60 days. There's got to be a report back within 60 days. And for this, relatively small period of time, it's to resolve a major question that quite frankly seldom comes up, but it's here in this case as to whether a divorce should be granted at all. And that's going to be difficult in a settlement conference. If we come into a settlement conference and say, we don't want a divorce at all, we can't get over that hurdle. How do we go forward? So we need to answer this question first, and then the settlement conference is either a settlement conference about a divorce, a legal separation, or, from my client's point of view, hopefully this matter doesn't go forward and they stay married.
Okay. All right. Thank you. All right. So here's my take on the situation. The parties have been married. Sounds like a second marriage, possibly for each. They've known each other for an extended period of time, but they've been married for about 11 years. The case has been pending since 21, late 21, and there's been one prior mandatory settlement conference that was moved forward. It sounds like Mr. Abel is very desirous to continue the marriage, and Ms. Abel is very desirous to not continue the marriage. And Mr. Abel is concerned of possible influence of family members, and that her judgment is clouded. And if he could just have a counselor talk to her, then that would clear things up, and she would come clear and be able to say whatever her true desires are. I guess what I kind of lean on is that Ms. Abel has an attorney, and that attorney has met with her, and he's representing that she wants this particular divorce. And certainly family members and family pressures do exist when their families are deciding whether to marry or to separate or divorce. There's certainly input that family members give, and some are more free to give that advice than others, whether that's prudent or not. So when I initially looked at this, I thought of the issue of competency and the like. The competency question is somewhat significantly moderated by the fact that the counsel is involved for Ms. Abel. If he had concerns about her abilities for decision-making and capacity to make proper decisions, there would be, I think, some concerns raised. Not hearing those, what I'm hearing is that Ms. Abel has made a decision that she doesn't want to continue with things. And while the statute does allow for counseling to occur, where it indicates that if the other party denies that the marriage or partnership is irretrievably broken, the court shall consider all relevant factors and shall either make a finding that it's irretrievably broken, or at the request of either party, send them to counseling and report back in 60 days and go from there. And then thereafter, it says that that they've either agreed and they've reconciled and things get dismissed, or they haven't reconciled, then we continue to say, yeah, it's irretrievably broken, and then the decree of dissolution can be entered. So given those facts, the fact that there's counsel for Ms. Abel, recognizing that families have input, recognizing that Mr. Abel wants to continue the marriage, takes two to tango, and here with the length of pendency of the case, I think that I'm going to deny the motion to strike the mandatory settlement conference that's set for this coming Thursday. While at that mandatory settlement conference, I can imagine that Mr. Abel would probably continue his similar stance, and she would continue her stance, and that may not be terribly productive, but it may, who knows? I don't know what will happen. I think we need to pursue that path, and so I'll deny the motion that was presented.
And Your Honor, just so the court is clear and the record is clear on this, at the onset of this case, after competency was raised, I did have my client meet with her primary doctor at Kaiser, and information was relayed to me that this was voluntarily and knowing. I've submitted that to counsel. So we're resting on that information. If there ever needs to be a time where we get her reevaluated, because it has been about a year or so since that was done, I'm happy to do that. And that's probably one of the issues we can discuss at on Thursday morning, probably most appropriate. But I just wanted the court to be aware of that we did forward that information on to counsel, and it's there.
Okay. All right. Thank you. So the order that was presented, I simply denied it and signed off on that, and we'll see everybody March 10th or March 9th. I don't see her yet. So we'll come back to that. Next, we have the Curtis and Wynn matter 19-3-423-08 on for presentation. We have present Ms. Baldwin, we have Mr. Zandy, Ms. Nguyen is present. And so I appreciate the council working through the proposed order and the effort that each extended. I looked through the proposals and the competing interests and revised issues. And I have an order here that I'm going to share with you. So you can all take. I took the liberty of just taking the last revision that was sent to me, and I forwarded that on. And I've made some revisions, and I'll forward that on to the parties now.
Perfect. Thank you.
Your Honor, I got to run to my office down the hall and grab that off my computer. If you could take me about 30 seconds or so.
Okay, well, we got the timer going. Go. All right, so it looks like Ms. Nguyen left, but she's back. You didn't miss anything when Ms. Nguyen, Mr. Zandy's running to do a printout of the document that we're discussing, and so we're just in hold mode. I think Mr. Zandy overestimated his speed. Just thinking of his younger days.
I can tell the court that it hasn't come through to my email yet, so he may be just waiting on his end.
Yeah, that's likely the case. Yeah, and the firewall at the county is pretty beefed up right now too. So.
And I heard the end of that, and that's correct. I'm not as fast as I used to be, and apparently neither is my computer. So I've got Miss Bliss down there watching it, and then when I'll have her print it off and run it in as soon as she can. Okay.
All right. I appreciate the party's patience. It looks like Ms. Turnbull is joining the conversation as we speak. So let's, as soon as she's on here, we'll go ahead and get started. So let's turn our attention to the Gavino-Cook matter 21-3 Baldwin, and also Mr. Zandy, and Ms. Turnbull has joined us. So Ms. Turnbull, can you hear me okay?
Yes, Your Honor. Thank you.
Okay, great. Thanks for being here. So I'll hear from Ms. Baldwin first, and then Mr. Zandy and Ms. Turnbull.
So in this case, it's been a while, but I'll remind the court, if you look back, you issued a letter decision in this case, and the letter decision makes it clear that the purpose of this hearing is not just simply to confirm that the GAL is working, but to review, essentially there's 3 issues that the court was really concerned with, and that had to do with exposure to the children to pornography, some domestic violence issues that were happening in the mother's home, and a couple of other items that the court had concerns with and wanted the guardian ad litem to investigate, and essentially paused issuing a temporary order changing anything in the existing parenting plan pending that. So that's really what we're here for today. My client still believes that the children are in direct danger, that children continue, at this point, the protection order, restraining order that restrain the children from having access to their alleged abuser has expired, and the children are now being directly exposed to that other individual. That leads my client to continue to have very substantial concerns. So we are asking, again, that the children be placed in my client's primary care, and we are interested in knowing where the guardian ad litem is in her investigation. If it's not complete, at least for the interim purposes, we'd ask that we set over no more than 2 weeks and come back.
Okay, thanks. Thank you. Ms. Turnbull, any updates as far as the interim review report?
My investigation is, I would say, kind of midway through, and the mother and father are giving very conflicting reports about what's going on. And so, I am going to need to look further into the collaterals to maybe get some clarification as to maybe where the facts really are, because right now the reports do differ widely.
Okay. And then, so in that February 7th order, the court indicated we'd have a interim report due today. So what amount of time do you think is necessary to kind of suss out those differences?
If I could have probably another 3 weeks.
Okay. Okay, thank you. Mr. Zandi.
No, and I think everybody, the one constant in this case, and the one thing that everybody agrees on is this is an absolute diametrically opposed position of each party on what's really happening here. So I'm not surprised to hear Ms. Turnbull kind of relay that information. That's kind of what we had suspected over the course of the past month or so. My client has various concerns, largely the same concerns that we expressed to the court back in at the hearing. I believe that was in early January. Those have not resolved. Some of the issues have unfortunately manifested and are getting potentially worse. Again, I think everybody knows what those are, and I don't want to rehash any of that, but I think getting the GAL comfortable with her recommendation and her findings is appropriate in this case, because we've got two kids who are being pulled in opposite directions. And I know that sounds negative, but when you look at the competing interests of both parties and the competing allegations, there's no way that can put these two kids in a comfortable setting. I think they do feel the stress of what's happening, whether anybody's relaying to them that information or not. I think kids are pretty receptive to that and can know when things are a little bit different and when there is conflict. And this is a high conflict case at this point. Hopefully that resolves. I think the first thing and the first measure to hopefully eliminate some of that pressure would be the GAL recommendation and getting some further order. But with that said, it needs to be, based on full input, full information, so that Ms. Turnbull, who's well equipped for these types of cases, but so that she can present recommendation to the court that makes sense given where we're at. Because this not uncommon to have different sides of the story being portrayed, but this one is pretty extreme. So I think giving that 3 weeks or however long is necessary to make sure that we make the right call on this is important for both these kids.
Okay, thank you. Ms. Baldwin.
Thank you. The primary concern that my client has, and that's a reasonable one, is that the children have some extreme exposures to high risk. Exposure to domestic violence, exposure to pornography, and exposure to their alleged abuser. Because those are so high risk, that's why the court set this interim review, is that if we allow those exposures to continue, the reality is that the children are likely to suffer harm. And my client would argue they are suffering harm and that they exhibit physical signs that they are being exposed to things that are extremely inappropriate. Given that, I appreciate where the guardian ad litem's at. I appreciate that these cases are difficult. I still lean more towards 2 weeks, that this case have priority, because again, we have two sort of younger children. They're grade school aged, but still in a position where they don't have a lot of agency to help themselves in this situation. And on an interim basis, I would ask that the children not have exposure to Landon, who is the alleged abuser of the children, because that is now happening, and that is just such a high risk, frankly, for both of those individuals. I'd ask that the court order that on an interim basis, at least till we come back in 2 to 3 weeks. That was the individual alleged to have shown the children the substantial amounts of pornography. There just isn't a reason, and that person's also a minor. There isn't a reason to put all of those children at risk when it's just not necessary for a period of 2 to 3 weeks.
Thanks. Ms. Baldwin. Oh, sorry, Mr. Zandi. Just one quick question to Ms. Baldwin. In your opening comments, Ms. Baldwin, you had mentioned that the restraining order had expired, and is that in relationship to Landon?
Yes. So there was a separate collateral case that was a protection order protecting the children from Landon. The court had sort of set this hearing close in time to that expiration, believing that we'd be able to make a decision here. It expired, I believe, a week or 2 ago, and the children have already been exposed to Landon. We're just asking that not happen until we come back.
Okay, thank you. Mr. Zandi, you had follow-up.
And again, I think to depict Landon as an abuser is patently false at this point. I think Landon is a minor. I don't think there's been any findings that he's abused these children. Granted, these kids should not be exposed to pornography by any individual, but I would remind the court that part of the, again, stark contrast in facts presented by both parties 2 months ago was information that was readily available on dad's own iPad that the kids had access to. So pinpointing who the culprit is here, who the party is that is exposed the children to this material again, is kind of in the purview of the GAL. And at this point, I understand Ms. Turnbull's position of wanting to make sure that she gets what information she can, because that's a big issue in the case. Provided Landon doesn't have any unsupervised contact with these kids, provided adults are around, provided there's no electronic access to computers or iPads or anything of the sort, I think that probably makes sense. But I understood the protection order or the restraining order that was entered back in August was kind of a temporary fix. It was only, I believe, 6 months based on kind of the information that the court commissioner had at the time, which again was pretty limited. Obviously, my client will adhere to whatever the court wants to do with that, and we understand the approach of kind of the biting on the side of caution. I think that does make sense. But when you look at the allegations, I just want to make it clear that Dad's certainly, and we provided information to that, certainly had his run with exposing the children to materials on the iPad that they played games on that is certainly not suitable for youngsters.
Thanks. Ms. Turnbull, any final comment?
Well, a couple thoughts. One is mom is not in a relationship currently and is abiding by your orders not to bring any boyfriends or anything around. So I don't think that the children are being exposed to any domestic violence in the home currently. And in talking to mom, I do think that the children do miss contact with Landon, being cousins. And I do need to finish my investigation, but I do think supervised contact, as long as it's well supervised and there's no electronics, may be appropriate for the interim.
Okay. All right. Thank you. Well, obviously there's heightened concerns based on the facts alleged from the father's perspective about the pornography and the domestic violence and the like. And there's an order in place from back on February 7th, which puts in place some protections, hopefully that will provide a degree of protection to the children. It sounds like the restraining order has expired. Therefore, the order contemplates supervised visitation between the children and Landon, and it has to be direct line of sight and hearing distance at all times and never left unsupervised with him. And so the court anticipates and expects fully that there be rigorous and conscientious compliance with that order. There's also protections there related to unsupervised access to any internet devices. So I think that also provides a level of protection also until we can figure things out a little bit more. So I'm sensitive to Ms. Turnbull's plight, where there's a strong disagreement on what has occurred or didn't occur, and needing to figure that out a little more clearly in her mind, which is a difficult task. So I'm fine continuing the matter to March 28th. That'll allow her time to complete that report, and we'll expect the report on that date so we can have some closure to these particular issues. There is one issue in the one provision in the the February 7th order, which it kind of reads like it expires today. And so just to remove any ambiguity with that, that's on E3 on page 2, where it says Madison-Cook is prohibited from allowing any introduction, contact, or exposure of the children to any romantic relationship partner pending review on March 7th. So I'm just going to write out a hand order that continues that particular provision and extending that to the next court date, which will be on March 28th, just to make sure that there's no ambiguity there and everybody's on the same page. Otherwise, I'll continue that order in full force.
Great. Let's go to
So
that then.
we'll see everybody else.
So we're now looking at
the Curtis and Wynn matter. The parties had expressed some concern or a possible disagreement on paragraph 4. So if we look at paragraph 4, looks like the parties made some adjustments themselves. And then I added on paragraph F, 4F, this is on page 2 of 12, 150 days, just in case there's extra conflict with signing up and the like. So I just granted a little more time to get those completed. This is related to transportation of the children. If you'll look on line 13, I've struck in the word huff, and I've struck in the words or have a prior alcohol impairment relating offense. So the last sentence reads, the child shall not be transported by any designee known to smoke, vape, any products. And that's in reference to the child's asthma. So I've made those revisions there with the strikeouts. And portions related to the passport provisions. Obviously, there's a lot of concerns about that, but I've stricken the language that says, and will further consider a motion for costs, including hotel, food, activities, rental car, other costs associated with the lost passport, and then I left in and return fees. So certainly the court can impose a sanction of the offending party, but it's not going to be related to, court's not going to be boxed in, so to speak. So, we'll consider all factors that are relevant. So I struck that language. And then if you look then at page 11 under J1, I struck the hair follicle or similar test and just left it at a year analysis. And then on sub 2, I changed it from 2 to 4 hours that they need to respond to any request for a year analysis. Under 5, I changed drug test to urinalysis test, struck drug or, and then struck the last portion that says shall be immediately suspended until further of the court, and replacing that with may be reviewed on motion by other party. Sub 6, I struck the last sentence related to hair follicle, and sub 7 relates also kind of the hair follicle. And so those are the provisions or changes that I made to the parties' hard work and kind of hammering that out, and I appreciate that very much. So with those changes, I've signed off on the order, and I'll just hear any strong disagreement or any reason not to enter that order.
No,
Not strong disagreement, Judge. Sorry, Ms. Baldwin.
No, go ahead.
Not strong.
It's fine. Go ahead.
Not strong disagreement, just clarification on that paragraph 8 on phase 4. And I did get the clerk's minutes just recently, and I haven't been able to look at those. When we pulled those, they weren't prepared yet. No midweeks on that phase 4. Is that the court's intention?
And that's what my notes reflected, and that is what is reflected in the clerk's minutes.
Okay.
And if it is, then I'll go with that. I just didn't have that information, and my notes were a mess. So
Yeah,
I'll take that for what it's worth.
Let me pull up my notes from the hearing date. And that was on the 28th, was it not? Also continuing the weekly midweek of Wednesday of 3 hours, 5 to 8. My notes, I put an orange star next to the rulings that I plan to make. And if I change them, and I change it. So my notes for that phase 4 indicate that alternating weekend, 1st, 3rd, and 5th, starting Friday at 6 p.m. to school on Monday, or 6 p.m. if no school. And then I put every Wednesday after school to Thursday after school, but I didn't verbalize that at the hearing. So there's an extended weekend. It's a Friday to Monday time frame, and I think that consistent contact is important. And so I actually omitted that from this order when I was reviewing it and the like. So I probably need to add that in there after on line 20 on page 4.
Was that every week or on the off week?
I have every listed.
Okay.
And if no school, I'm assuming 6 p.m.
Yes. For every Wednesday from after school, or 6 p.m. if no school, to Thursday after school, or 6 p.m. if no school. Okay, with that revision, we'll submit that Patterson matter 22-3-39608. There we have Ms. Baldwin representing Lacey Patterson and Mr. Fuel representing Thomas Patterson. Ms. Baldwin is present, Mr. Fuel is present, Ms. Patterson is here, Ms. Height is here, and Mr. Patterson is here. I did review Ms. Height's guardian ad litem report. Thank you for submitting that. I appreciate your efforts there. So I've read over that, and I've read the pleadings that have been submitted by the parties in relationship to substances, and in particular dextromethorphan, I believe is how you pronounce it, and the substance use disorder treatment that Mr. Patterson has undergone and the like. So I've also reviewed income information that's been lifted up just recently. So I'll hear from Ms. Height first, if you have any comments to lead out, and then I'll turn the time to the parties.
Thank you, Your Honor. I do have a few things to maybe illuminate my report a little bit. I spoke with providers Tucker, Johnson, and Lovely subsequent or during the filing of this report, and have a clarification and information that made me comfortable with what I had already put in my report without their written reports to me. I felt like what I heard from them was accurate, and what I included in my report was accurate. I do have I don't know if it's really a concern. I guess I'd like to just offer it as a clarification for your honor. I don't want to minimize the concerns that have been brought forward by mother in this and the way that she feels. I also don't want to overreach in providing relief or security for mom in a way that creates a negative impact on the kids as far as their relationship with their between the children and their dad. I would like to just remind the court that there has never been allegations of domestic violence or abuse of any kind toward the children. So I didn't really have any concerns there. I guess the core of my concerns are that behaviors by Mr. Patterson have been identified by the professionals as stalking and domestic violence. And those seem to conjure up much more dangerous effects than what I'm seeing in this report. While I understand that's kind of the clinical designation that need to be used, when I spoke with Ms. Lovely and read her report, she also agreed that calling this stalking and domestic violence may be an overreach verbally, but it fits in the clinical approach that she took. She agrees that the domestic violence treatment that she has recommended and that I have recommended really will lean more into boundary work for him rather than kind of a standard domestic violence that might be thought of by the court. So I just wanted to, I guess I just wanted to soften those words a bit for your honor as to what I am thinking here.
Thank you, Ms. Height. I appreciate that softening. So let's hear from the petitioning party, Ms. Baldwin, and then Mr. Fuel.
So first off, we're only here to review the guardian ad litem report. And the report's been filed and it's before the court. Courts and different members of the bench take these hearings differently. Some say the only purpose is to review the report. And if you want to change the existing plan, someone should file a motion, and then everyone should have an opportunity to fully respond to that motion before we go forward. And in this case, there's also the sort of late breaking psychological report. We only received that a few days ago. That was filed. And so that's another concern, is that my client really hasn't had much of an opportunity. It looks like it was filed, and now I can't say that it was filed, but it's signed March 2nd, which would have been Thursday. And as Your Honor is aware, I was in trial Thursday, Friday. So we haven't had an opportunity to respond to that. That psychological report has a number of sort of red flags that my client would like to better address and flesh out for the court, sort of her concerns around that report. And so if the court's considering making changes to the temporary order, at least the temporary parenting plan, we'd like an opportunity to be able to respond to that. And so we would ask the court set this matter out at least 2 weeks so we can respond to that psychological report at a minimum before we make changes. Similarly, we're not on to address financial matters at all. Counsel sort of attempted to bootstrap that in, and that just isn't what we're before the court, no matter how you slice it, to address those issues. So if we're going to address those issues, those should be required to be via a motion. So those are my requests, is that we set the matter out, give my client an opportunity to respond to those late breaking items that are somewhat impactful. There's a number of red flags in that psychological report that would indicate cause for concern. Again, my client doesn't want to keep the children from the respondent, but she does feel that it's important that we have a safe, logical, sane way forward that leaves those boundaries intact.
Thank you, Ms. Baldwin. Mr. Fuel?
Thank you, Your Honor, which is exactly why the court, I presume, ordered a guardia ad litem. I certainly am at a bigger disadvantage in this court than Ms. Baldwin. I'm sure she's correct. I know that my experience throughout the counties I more commonly practice in is that some courts will require a motion and some won't. I think Ms. Height really nailed the issues at hand, Your Honor, and clearly in her report, she dealt with and absorbed all the professional aspects of this case. I don't know that kicking this thing out a couple of weeks to make changes makes a lot of sense, other than just delaying the inevitable. If the court is considering that, I would ask that the court go ahead and implement parenting time now on maybe a 2-week or interim basis until we come back. Certainly, Ms. Height is qualified to make a recommendation. She again reviewed everything. In fact, our position would be that because it seems pretty conclusive by all the experts and our guardian ad litem, and as Ms. Height brought to the court's attention this morning, that this is not a domestic violence case as the court normally is concerned about. I came in late, so I don't know to the extent that this court is familiar with what the allegations are. Certainly, the record seems like it's probably pretty clear, but we would, if the court is going to go ahead and make some modifications to this parenting plan, whether, like I say, interim or as a new temporary parenting plan, we would like to be heard on refining some of the recommendation points that Ms. Height made in her recommendations. And so if the court is interested in hearing those arguments, I'd like to make them, but I guess I'll let the court respond.
Okay, thank you. So I guess my general approach to GAL reports, once they're filed, GAL reports will strike different parties in different ways, obviously, when the recommendations are made or factual assertions are brought forward. So the GAL brings those forth, lays them out on the table in front of everybody, and everybody gets to pick up particular cards and they get to flash those around and argue which ones they want. So in my mind, when a guardian ad litem files their report, it's fair game. The issues are there before the parties, and the court's read that, the parties have read that, and so then everybody's apprised with the backstory and also the new information from the GAL, and so the issues are on the court's table, if you will, to decide. So that's just in general. The Dr. Johnson's report, while it has not been formally filed or penned, at least I don't think I've seen that. There were some initial recommendations or information that Ms. Height had shared in kind of thumbnail form. And it sounds like that report has been formally finished as of March 2nd, and there was some additional information that Ms. Height provided on that to the parties. I tend to agree with the parties that with Ms. Height's rendition of the domestic violence tag that's attached here, the allegations are that there was either a single day of recording or a period of months of recording. There's no indication that there's been violence towards the children in the traditional form of hand to backside or hand to a swat to the head, or violence in the physical violence of like holding or restraining or punching or kicking of the other adult in the marriage. So that we don't have that. Domestic violence can be broadly defined and narrowly defined, and here there's a clinical rubric that Ms. Lovely has works with and has worked for a number of years, and that it fits within that clinical rubric of domestic violence. I appreciate Ms. Height's kind of clarification or putting words to that of maybe boundaries. Boundaries are an issue, and domestic violence is about control, and control relates to boundaries. And so I can see why Ms. Lovely may, with her expertise in domestic violence, would classify it as such. Because there are the information from Dr. Johnson isn't fully fleshed out. At least I haven't fully been apprised of the full report. That I think it's important that we have that opportunity to review that in 2 weeks on the 21st of March. So I'll grant the continuance for that purpose to look at that, because the guardian ad litem does make recommendations as to parenting plan and holidays and the like. There's recommendations related to SUD and contact issues, exchanges and SUD and dextromorphan, if I pronounce that correctly. So there's a lot of issues that are there. And I think also even the issues of, the substance uses, including alcohol and cannabis, that's on the table. There's a potential, I think we need to probably address potential issues as far as incomes, with an indication of, there's an indication that the father's indicating his salary is fairly set and there is some bonus, but it's a fairly low level. And that there's an indication that, at least from his perspective, that that the mother's income does not reflect any bonus monies that she may have received. And so I don't know if 2 weeks is going to be enough for the parties to address those issues. I think it will. And there's also issues of spousal support. And I think the spousal support, that needs to be a separate motion that's brought, because it's not necessarily brought up. And I think the child support, I guess the guardian ad litem report doesn't really address those particular issues. So there's kind of these issues that have been raised by Mr. Patterson, obviously of a concern to him. But I think if there's a motion, it would be appropriate to have a motion for child support modification and spousal support modification. I think that's a cleaner way of approaching it, because here we're on a guardian ad litem final report, which of course touches upon those issues, but indirectly. So there would need to be separate motions for that. I know that there's been information filed at this point that the court's been apprised of, and then we need to hear the other vantage point. So that needs to be heard separately. And if parties can have it noted up within 2 weeks, great. If that takes a little bit longer, then we'll address it once it gets ready.
So I guess it's a little bit on Mr. Fuel. 3 weeks is what the current local court rules say. That would take us to the 28th if he filed his motion today. I'm happy to, if he files his motion today, address everything on the 28th, or if he wants to just run it separately. Both are fine with me.
And Your Honor, I'm going to ask the court if the court is indicating that we're not going to budge on a change in the parenting time pending the next hearing, then we want that next hearing as soon as possible, because obviously the parenting time is really the 90% of what we're talking about in this case. And so if the court is considering not giving my client any expanded parenting time in the interim, then we want that hearing to be as soon as possible. However, if the court is going to give us some interim parenting time to match the recommendation of the court-ordered GAL, we would ask, what we can do is go ahead and I can cite the modification motion along with with this review on the 28th. At least I believe at this point, like the court mentioned, I think everyone here at least understands the position of Mr. Peterson on this issue. So I know that there's not a notice issue, although I do appreciate that there's a sort of a pro forma procedural issue that we need to resolve. Okay, so we will set this matter over to the 21st to address the parenting plan issues raised by the guardian ad litem report. And it sounds like the other issues of child support modification and spousal maintenance will be cited on, and that'll probably be in either the 28th or first part of April. So we'll look for those citations to come through, and then we will see everybody on the 21st to address these important issues.
All right, very good, thank you.
Your Honor, just for the record, I did file the Johnson report, but I am guessing that it's en route to the courthouse in Your Honor.
I think that's an accurate rendition. It's in process. Yeah. Yeah. And that'll allow that to be received and reviewed fully. So I think that's probably good too. Okay. All right. Any last issues, Ms. Height?
No, Your Honor.
Okay. All right. With that, thanks to the parties. We'll see everybody on the 21st.